Barry Lehman here. Today we're talking about circulating resolutions. When I talk to founders and other people involved in the startup space, many of them don't realise that they don't necessarily need to have a meeting of directors or shareholders in order to pass a resolution of their companies. Perhaps one of the problems in some startups is that governance via meeting seems hard when you already have a lot of pressure on you in business development, operations and product development in a small team. But there is a way to achieve good governance and avoid time-expensive meetings via the process of passing a circulating resolution. I am in the process of building a corporate governance tool which will help small companies keep a minutes and resolutions book in the cloud. The idea is that it should be easy for shareholders, managers and directors to make decisions which affect the company in a structured way where resolutions and voting are recorded online. What better way than to use software and move away from the problems of the paper paradigm? You can see my other presentation on digital ubiquity and the end of paper if you are interested in the death of the paper paradigm. To that end, the first decision-making workflow that this tool will offer will result in a circulating resolution and voting come signing mechanism. So, what is a circulating resolution? To find out, we turn to the source of companies law in Australia, which is the Corporations Act 2001 Commonwealth. So you've got two streams of resolution making. One is via the directors, and one is via the members of the company or the shareholders. So the directors, this is section 248A, the directors of a company may pass a resolution without a directors meeting being held if all the directors entitled to vote on the resolution sign a document containing a statement that they are in favour of the resolution set out in the document. When is the resolution passed? The resolution is passed when the last director signs. So you might already be thinking about how that has some implications for notice. Over to section 249A, this provides the circulating resolution mechanism for shareholders. First of all, it's got to be a proprietary company, so it can't be public, and the company, if you look at 249A subsection 2, a company may pass a resolution without a general meeting being held if all the members entitled to vote on the resolution sign a document containing a statement that they are in favour of the resolution set out in the document. So they're pretty similar there, both of those requirements, and you'll notice again on the shareholder, in the shareholders section, that there isn't a requirement for notice because the resolution is passed via subsection 4 when the last member or shareholder signs. Right. Here we've got a case called Wilson and Indigenous Services Pty Limited number 2. It involved the construction of the powers of an advisory committee as defined in the trust document to remove a trustee. In the absence of governing legislation like the Corporations Act, it is necessary to read the governing documents of the entity. Furthermore, even if governed by the Corporations Act, it will be necessary to confirm if any company constitution or shareholders agreement modifies the rules contained in the Act around circulating resolutions. The decision made some interesting points when interpreting whether a circulating resolution was valid. At 116 it said, no provision in the trust deed for how the advisory committee is to exercise its functions under the trust deed other than at a meeting. So there was no provision in this particular trust deed saying that they could do a circulating resolution. And contrary to that, one of the subclauses provided that specifically a convening of a meeting to appoint or remove or replace a trustee was required. And there is no provision in the trust deed for a resolution in writing in any circumstances. So part of the reasoning as well in that case involved the idea that members of the Indigenous community, which the trust deed was for, actually needed to be able to all meet in person so that they could discuss what was happening. Right, so can an email exchange constitute a circulating resolution? So in this case of United Muslims New South Wales Incorporated and Australian Federation of Islamic Councils Incorporated Number 2, Islamic Council of Victoria Inc. and Australian Federation of Islamic Councils Inc., there is a suggestion that it can. In the decision, it was noted that the defendant suggested an email exchange was in effect, this is the counsel representing the defendant, suggested an email exchange was in effect a circulating resolution of the Federal Council. However, the judge went on to say that Dr. Janeed's 8 April email sought your views. He did not indicate that this was to be a vote by way of a circulating resolution of the Federal Council. I am not suggesting that a high degree of formality is required for such a resolution, but at the least it needed to be made reasonably clear to all concerned that they were being asked jointly to exercise a power belonging to them, and not simply being engaged in a consultation process. That was not done. So there's an indication here that there's a level of formality that's required in order for an electronic communication to constitute a circulating resolution. The entity in that case was not governed by the Corporations Act. However, we can look at the electronic transactions legislation for guidance. The Corporations Act requires signatures and a document. In the Acts Interpretation Act 1901 Commonwealth, we've got the definition of a document in section 2B as meaning any record of information, and includes A, anything on which there is writing, and B, anything on which there are marks, figures, symbols, or perforations having a meaning for persons qualified to interpret them, and importantly here C, anything from which sounds, images, or writings can be reproduced with or without the aid of anything else, and there's D, a map, plan, drawing, or photograph. So, just to recap, we're asking the question of whether an email exchange can constitute a circulating resolution. We've got some dicta from a case not being involving an entity that's not governed by the Corporations Act, saying that there needs to be a certain level of formality. And then we're having a look at the electronic transactions legislation to see how that goes along with the requirements in the Corporations Act for a document and signatures. So the electronic transaction legislation allows us to use electronic communications as a means of satisfying the requirements of writing and signatures provided for in other legislation. One of the key things for the writing requirement, which we have up here on the screen, is the consent to the information being given by means of an electronic communication. So that's it here, which is 8.1b. The signatures provisions are slightly trickier, and I've already underlined here some of the key parts of it. You've got to use a method which identifies the person and the person's intention, and it's got to be as reliable as appropriate for the purpose for which the electronic communication was generated or communicated. So, we've got some writing in an email that satisfies the meaning of a document. Because if you recall, a document is anything from which sounds, or includes anything from which sounds, images, or writings can be reproduced. So that's bits of information in a computer. Okay, and we've got a signature via email communication. So the email address of the person could sufficiently identify the person, so long as they say something like, yes, it's my intention to sign, to electronically sign this email that I, sent to the decision. You've got a situation now where the consent is made reasonably clear and the exchange of emails could have the effect of a resolution. And so an email exchange probably can constitute a circulating resolution. However, you would probably want it to be more formal and contained only in one document. It might be tricky to, if something ever came before a court, it might be tricky to figure out whether a certain part of the email exchange is the resolution or not. And this is especially so when we consider the requirement for keeping minutes. So under the Corporations Act, Section 251A, we've got the requirement for keeping minutes. The company must keep minute books in which it records within 1 month proceedings and resolutions of meetings of the company's members, and proceedings and resolutions of directors' meetings, and resolutions passed by members without a meeting, and resolutions passed by directors without a meeting. So that's the bit which applies to circulating resolutions. And you've also got to have, after the meeting, the document being signed by the chair of the meeting. So that's if you've had the meeting. And there's also a requirement of where you're meant to keep the minute books. And importantly, we've got subsection 6, which is that a minute that is so recorded and signed is evidence of the proceeding, resolution, or declaration to which it relates, unless the contrary is proved. So what you have there is a prima facie situation in regards to what the resolution of the company actually was. I find it useful sometimes to consider legislation from other jurisdictions. Here we have the equivalent sections from the Delaware Corporations legislations, where a circulating resolution is referred to as a consent. If you read through it all, it's all sort of fairly similar to the Australian Corporations legislation. And so, for example, we've got a consent must be set forth in writing or in an electronic transmission. So they already they mention that specifically, and any person executing a consent may provide, whether through instruction to an agent or otherwise, that such consent will be effective at a future time, including a time determined upon the happening of an event occurring not later than 60 days. So in fact, you've even got sort of more scope there. And is there anything else which we need to have a look in here? No, not particularly. But anyway, it's useful to look at these things because it helps to consolidate meaning. So while the legislation talks of passing resolutions without a meeting, we can think of the process of passing a circulating resolution or a consent as an asynchronous meeting. The outcome, a resolution, is processed by those who vote on it at different times. They don't have to be in the same room. The resolution is passed when the last director or member signs. This clearly has its benefits. People are busy and live in different time zones. One director or member may have an idea to do something for the company which requires the consent of the other directors or members, but which doesn't warrant discussion. However, what might be some of the pitfalls associated with relying on this process? What about non est factum? It's not usually sort of a successful plea, but I think in the electronic situation, maybe there's something to it. What if a resolution is attached to an email, and the email's message, the email message has an explanation of the resolution, and the director assents to the resolution by return email, but they haven't necessarily opened the attachment. Well, you might say that it's careless. And we've also then got to consider, the electronic transactions legislation again, which we already have, about signatures and writing. So here's a pertinent case around emails, electronic signatures, and the like. The case is Obella Fresh Dips and Spreads Pty Limited and Coetzee. In this case, an unscrupulous finance manager was found to have defrauded his employer in the amount of about $3 million. The fraud involved Coetzee forging signatures of the company's ANZ General Manager, Mr. Chris Elliott, who was the signatory on a cash advance facility for the company. Apparently appropriating the money so what Coetzee did was that he apparently appropriated the money for a proper purpose, but instead he transferred it to his own bank accounts, and the fraud was then attempted to be covered up with additional forgeries. So I'll just read from some of the sections of some of the paragraphs of the case. In May 2020, Mr. Coetzee forged Mr. Elliott's signature and also the signature of the Chief Financial Officer of Obella on a circulating resolution approving the financial statements for Obella. Mr. Elliott's signature was forged on the financial statements. So all of this was able to occur because it was done electronically. As now analysed by forensic accountant Mr. Bell, by 57 fraudulent transactions, Mr. Coetzee transferred about $3 million from Obella's bank accounts to his bank account, or in respect of another 1.4 into joint bank accounts with his wife. Of these money, Mr. Coetzee falsely represented that 1.6 amount were payments for Obella's tax, and about 800,000 were royalty payments to Pepsi. Numerous other reasons were given for the remaining money, and none of it was true. So, this case sort of highlights some of the concerns that we should have around maintaining good controls in a company, and it also highlights how we should, if we're going to use electronic communications, which of course make it all very easy, how we need to make sure that we have something which sufficiently identifies the person whose signature is purportedly on the electronic communication. It seems as if in this case it was really quite easy for Mr. Coetzee to forge these signatures. Now, I would just also mention that it's just as easy to forge signatures in the paper world as it is online. It's just that potentially we've got a velocity issue here, where in the electronic world it's faster to be able to send off a document with a forged signature on it. It's probably, maybe if you're not a very good forger of signatures in handwriting, it might be easier to do it with just copy pasting an image file into a document than it is sort of spending some time trying to forge a signature. But in any event, the point is that if you've got a proper control in place in the software world, you can probably avoid these sorts of things happening. Whereas in the paper world, you would have a situation where there's just a bit of paper and anybody can come along and learn how to write your signature and put it on any bit of paper and commit a forgery anyway. So I think that in the end, there is a distinct security advantage in using electronic transactions vis-a-vis paper transactions. Right, we mentioned before about notice, and the reason we were talking about that is because the directors of a company would ordinarily be entitled to notice, as would the shareholders, if they were to be passing a resolution via the meeting mechanism. But as we've pointed out before, when you've got a when you're doing a circulating resolution, you don't need notice, because what happens is all of the directors entitled to vote on a resolution have to sign the document, and they have to be in favour of the resolution, and it's just not passed unless that happens. So it's not as if the notice requirement necessarily matters, because nothing's going to happen unless everybody signs the document. And I think that that's an important point to make, and that's what gives it this sort of asynchronous feature. Here's a case which I'll just read from, which is body corporate for 11 Joseph and D. Cirolo Pty Limited as trustee for the Cove Trust 1. This is a Queensland tribunal case involving a body corporate, and what happened in the case was one of the lot owners in the body corporate wanted to raise a levy. It was about $2,000, and they claimed to do it they just claimed to do it, and the other lot owner, I think there are only two lot owners, the other lot owner just never signed it. So I'll just read from the paragraphs here. Of the points made by the respondents in response to the claim, the adjudicator concentrated on one. This was whether the 16 March 2020 vote to levy the contributions had been valid. The case for both parties was that the scheme was governed by the Small Schemes module, and so this meant that the circulating resolution of 16 March 2020, which purported to levy the contributions, could only be done in accordance with the requirements of Section 111 of the BCCM Act, that's the Body Corporate Act in Queensland. The adjudicator decided that this had not happened because Section 111 required all lots to vote in favour of such a resolution, and the respondents had not voted at all. Hence the resolution had no effect and the contributions were not validly levied. At 62, it can be noted that the adjudicator dealt with this claim with considerable efficacy by concentrating on only one issue where it was clear that there was a breach of procedure on admitted facts. That was the failure to follow the voting procedure required by Section 111 of the BCM Act. Although I've given leave to appeal, I've concluded that the adjudicator was right to dismiss the claim on the grounds that the processes required by the BCCM Act had not been followed, because Mr. Liu failed to prove that the body corporate could properly bring the claim. So, we were talking about notice, and as a question mark around circulating resolutions, and it doesn't matter because you've only got a valid resolution, and although this doesn't involve the Corporations Act, it's a similar provision. You need to have all people who can vote on the resolution vote on it and vote in favour of it, and in fact they only do that by signing the document saying that they approve it. Right. Here's just a specific thing to bear in mind regarding one of the limitations of circulating resolutions, and this is purely from the Act, from the Corporations Act, which is around the removal of an auditor. Section 249A(1). This section applies to resolutions of the members of proprietary companies that this Act, or if a company has a constitution, the company's constitution requires or permits to be passed at a general meeting. It does not apply to a resolution under Section 329 to remove an auditor. Right, so here the thing to note is that a requirement for audit and an auditor is not generally required for a small proprietary company, so it's not necessarily relevant. A small proprietary company has to prepare the financial report and director's report only if A, it is directed to do so, it was controlled by a foreign company, and or it has one or more CSF shareholders at any time during the financial year. The rest of this part does not apply to any other small proprietary company. So CSF is crowdsource funded shareholders. Section 325 provides for auditors and crowdsource funding for audit where the company has raised 3 million or more in CSF offers. So a small proprietary company can have an auditor if they've engaged in a certain level of CSF funding, and then that would mean that there might be a situation where the members want to remove an auditor, and if they want to do that, they can't use a circulating resolution to do it. So there's just one tricky little pitfall in a very specific situation. This was a couple of cases, this was the resolution that I've got on screen was the focus of the litigation. In the decision below, before Ryan J, His Honour found that Mr. and Mrs. Jagatrumpka, by voting on the 2008 resolution and advancing the guest house purpose, this was, I suppose I should give a bit of background before getting into it. This was a husband and wife. The husband was an executive of what became Wollongong Coal. In 2008, they lived in India and didn't live in Australia at all. And there was this idea that when he visited, they could move out of a flat that they were in Wollongong and into a nicer house on Cliff Road. And this is only when they were visiting, and when they weren't visiting, other executives of the group could use it, and it could be used for functions and the like. Now, the litigation came about because it turned out after 2008, after some years, that the Jagatrumpkas ended up living in the house, and so when he resigned as a director, the remaining directors of Wollongong Coal wanted to sue them for having pursued an improper purpose and a breach of fiduciary duties and so on. And anyway, so we should get back to the resolution, because this was a circular resolution, and it's rare that you actually ever get any of the text of directors' resolutions in the case law, and so it's interesting. So they resolved that the company is authorised to purchase the entire shareholding of this shelf company, and then they've got this note section underneath, which is that there's a rare opportunity to acquire a property, Cliff Road, and they'll buy the property for around 5 million, and then demolish the house and develop the property into this Lux pad which was built. So so back to where we were in the case in the matter below, in the proceedings below. The judge said Mr. and Mrs. Jagatrumka, by voting on the 2008 resolution and advancing the guest house purpose, this is what I've been talking about before, when they in fact held the exclusive residence intention, which is what happened afterwards, which they did not disclose, improperly used their position to gain a benefit for themselves which they did not declare, in breach of their fiduciary duties to WCL, including the duty to avoid a conflict of interest and the duty to act in good faith in the interests of the company and for a proper purpose. The Jagatrumkas also breached the duties imposed on them by subsection 1811 and 1821 of the Corporations Act. So in the first proceedings, the judge went through a whole process of looking at links in the chain and using inferential evidence to make that finding. But on appeal, the appeal was allowed, and that decision was overturned. And it was overturned because the judges in the appeal proceedings found that a lot of the inferential evidence, most of it, was ambiguous, and so it didn't say anything around what the intention. They were saying that it didn't say anything around what the intention of the Jagatrumkas, what their intention was, and so it wasn't for the judge below to actually find this, and therefore the resolution which was written was actually what the company was doing. It was pursuing a proper purpose, in that they were going to create this house where people could stay, who were executives, and this goes back to the point of the prima facie evidence of the resolution. But you may have read a bit more of the resolution by now while I'm talking about that case, and you might be wondering about certain things that stand out in the resolution. Well, I certainly was when I read it. Why were notes tacked on to the end of the resolution and not included in a background statement prior to the resolutions? Why were these notes part of this resolution document and not confined to a resolution document of the newly acquired subsidiary, which would be the purchaser and developer of the identified property? Even if the reasoning for the purchase of the particular property should have been included in a resolution of the head company, why were they not more extensive? All of the litigation that occurred was potentially because the reasons for whatever it was that the reasons for making the purchase of the property weren't necessarily sufficiently documented. I think that this resolution highlights an issue with separation of concerns. The beauty of circulating resolutions is that they can make the administrative and decision-making life of a company flow more easily. However, reasons for decisions need to be separated logically. Here, the reason for acquiring the subsidiary was that the company needed a new subsidiary to house a new project, with the goal of acquiring a property for visiting executives to stay in, on the basis that over the long run this would be a more cost-effective pursuit than paying for other means of accommodation for executives, which could be very expensive. A particular property need not have been considered in this particular resolution. It was then for the subsidiary to document the sources of funds, a loan from the head company, and uses of funds, identify a property, and terms of purchase and development of accommodation with a sound financial rationale, and document this in its resolutions. So I would just say that sufficient detail is important. Without it, directors open themselves to the risk of litigation about what the actual purpose of a company's decision might be, and if that decision is a proper purpose or not. Although it wasn't mentioned in the Jagatrumka proceedings, subsection 251A6 of the Corporations Act is of significant importance to directors and shareholders. Thank you.